Criminal law represents one of the fundamental sectors of the legal system, as it regulates the exercise of the state's punitive power against behaviors considered harmful to the most relevant interests for social coexistence. It is defined as the set of rules to which the state, by threatening a sanction, prohibits certain human behaviors classified as crimes. The primary function of criminal law is therefore the protection of society from crimes, that is, from those individual conducts that attack or endanger legal interests considered essential. Among such interests are, by way of example, life, physical integrity, honor, property, public faith, and many other fundamental values. When the harm or endangerment of these interests becomes significant enough to threaten the overall legal order, the system reacts to the application of criminal sanctions. Conversely, when the offense is of lesser seriousness, the legal system prefers to resort to civil sanctions, such as compensation for damages, or administrative sanctions, such as monetary penalties for traffic violations. General features of criminal law. Criminal law presents a series of features that define its nature and its position within the legal system. First of all, it is positive law, since it can derive exclusively from legal norms established by the state through formal acts. It is also state-based law, since only the state is authorized to issue criminal norms and exercise punitive power. Criminal law is also autonomous because it develops its own concepts and categories without depending on other branches of the legal system, while remaining coherent with the system's general principles. Finally, it is public law, as it aims to protect the general interest in security, preservation, and progress of society. The criminal norm and its elements. A criminal norm, in the strict sense, or incriminating norm, is the legislative provision that prohibits specific behavior and provides for the application of a penalty in case of violation. The constitutive elements of the incriminating norm are two: the command and the sanction. The command consists of the order or prohibition to perform a specific action or omission. The sanction represents the legal consequence that derives from the violation of the command. General provisions of the criminal code that do not describe crimes but merely define concepts, structures, or general institutions cannot be considered criminal norms in the strict sense. In this category fall, for example, the norms that specify the structure of the crime, the grounds for excluding punishability, and the rules governing concurrence of crimes or participation of multiple persons. Features of the criminal norm. The criminal norm presents certain essential features that determine its function and effectiveness. The first feature is imperativity. Once in force, the criminal norm becomes binding for all individuals within the territory of the state. The second feature is state authority. The criminal norm originates exclusively from the state and cannot be created by minor public entities, private subjects, or unincorporated international agreements. Therefore, provisions contained in the statutes of public or private entities or in international conventions lacking legislative implementation cannot be considered criminal norms. The guarantee function of criminal law. Criminal law also performs a fundamental guarantee function, as it limits the punitive power of the state and protects the fundamental rights of the individual. The principle of legality, expressed in the formula nullum crimen nulla poena sine lege, ensures that no one may be punished except by virtue of a law that defined the act as a crime before its commission. This principle guarantees predictability, legal certainty, and protection against arbitrariness. The role of criminal sanctions. The criminal sanction does not have only a repressive function, but also a preventive and a rehabilitative one. General prevention aims to dissuade the community from committing crimes through the threat of punishment. Special prevention, on the other hand, targets the individual offender with the aim of preventing further unlawful acts. The rehabilitative function, established by Article 27 of the Italian Constitution, requires that punishment aim at the social reintegration of the convicted person. Conclusion. Criminal law, although being the most incisive and effective tool available to the state, is also the most strictly regulated precisely to avoid abuses and ensure respect for fundamental rights. Its function is not only to punish, but also to prevent, protect, and guarantee the overall balance of a civil coexistence.